SJC-12199, Commonwealth versus Howard.
Demond, good morning.
Good morning, Your Honors. May it please the Court, my name is Sharon Demond. I represent Mr. Clyde Howard. If I may, I'd like to begin by arguing how Mr. Howard was entitled to instruction based on sudden combat, especially when viewed in combination of the erroneous insertion of the phrase threatening gesture.
I looked at the cases the Commonwealth cited on threatening gestures in the footnote in Commonwealth versus Nimick, dicta recently in Commonwealth versus Dyer, and then another case that wasn't cited, Commonwealth versus Weaver. And all three of those cases said that threatening words and gestures was an appropriate instruction outside of the context of self-defense.
I would suggest to the Court that those, especially in Nimick case, the three instructions were given, granted. However, the main defense was self-defense. And I would suggest in that context, the victim was stabbed in the back, and the Court essentially said the reasonable provocation is not offered here by the defense. So the only defense was self-defense. So again, going back to the instructions as set forth by this Court in 2013, that phrase is specifically missing from the instructions. Now, without the mere gesture, looking at case law that this Court has essentially stated in the context of reasonable provocation, the Court has always come back and said there needs to be a plus factor, if you will, that mere words are not enough, that essentially walking hastily is not enough. But then conversely, in those cases, this Court has said that this is not a case where there's mere words plus walking hastily plus some menacing act. This is not a case where there are raised hands. This is not a case where there is shouting involved with the walking hastily. So I suggest to the Court, in essence, the Court is saying that there needs to be a combination of the factors. In this case, there is certainly a combination of factors. The same factors the trial judge essentially outlined, reflected in the holding of the trial judge, and the evidence in the case being the deceased, Big Mo, considerably larger, 30 years younger, walks towards the defendant hastily. That's evident by video recording showing the defendant stationary and the deceased coming into the frame.
Okay, so along those lines, as you marshal the facts in the light most favorable to the defendant for the purposes of a sudden combat instruction?
That is exactly, precisely.
Tell me how it is that the jury could find beyond a reasonable doubt that the killing was not with sudden provocation, but have been able to find that the Commonwealth would not have proven beyond a reasonable doubt sudden combat. How could you contemplate that possibility?
Well, what I'm contemplating is a combination. What I'm saying is it's the jury instructions with reasonable provocation and sudden combat essentially collapses together, which is what the trial judge essentially said. So there was no reason not to give sudden combat.
They're redundant?
I'm sorry?
Are those instructions redundant?
Well, there are two distinct instructions, as the Commonwealth said, that this Court set forth in the model jury instructions. However, when you look at the definitions used in the course of the case law, the instructions are identical, or the holdings of this Court is identical, where they address the sudden combat and reasonable provocation. In a number of cases, this Court has said sudden combat or reasonable provocation.
I guess that's because when somebody slugs somebody, it's sudden combat, and it arguably could be reasonable provocation. But nobody slugged anybody here. You had no physical contact, even alleged, apart from the bullets going into the victim.
That is correct, and that's partially what the trial judge essentially held, that there needs to be blows or attempted blows. What I'm suggesting is that, respectfully, There is no requirement, for attempted blows. The instruction, the jury instructions, essentially equates sudden combat to sudden assault. When you look at the definition of assault by case law in Delgado, one of the definitions of assault is menacing conduct with intent to put the other person in fear.
Doesn't sudden combat entail a fight gone bad?
I'm sorry, say that again?
Doesn't sudden combat essentially entail a fight that has gone bad, and here we have no fight?
Well, but again, looking at the definition of sudden combat in the context of jury instructions set forth by this court equates sudden combat with sudden assault. And the definition of assault is not to have a fight, it's essentially a menacing conduct to threaten the other person.
Can I
And
ask
we
you a clarifying factual question?
Sure.
On that topic? In the light most favorable to the defendant, the victim, who's larger and younger, has his hand to his side, correct?
Correct.
And then we also know, I assume from the autopsy or photographs or the like, that he had a box cutter on his hip?
That is correct.
Right. Was there any evidence that he brandished the box cutter, that he had used it, that he took it out of its sheath, that it was, because, I mean, I think there's a difference between someone who has a box cutter on the street, perhaps, and then someone who works in a warehouse or is an electrician or a carpenter who carries that as part of their trade.
Well, Your Honor, the carrying it is not the issue, I would suggest. Reaching for it would be, where there is
Evidence that he reached for it as opposed to he has a box cutter because he works in a warehouse and cuts up cardboard, and he had his hand to his side.
that I would suggest to the court, in the context of this particular case, he has a box cutter, he goes for it while approaching the defendant and yelling so loudly that the person that's there can't even decipher the words.
What's the evidence that he goes for it? What specific evidence is that?
That he reaches to his right side, to the belt area, and then, most importantly, that the box cutter with a sharp blade is discovered where he reached for to the right side.
Was it out of its sheath or open when it was discovered on him?
It does not say. I don't believe the transcript reflects or the testimony reflects.
Does the transcript or the record show what was being yelled?
No, that it was so loud. The testimony was it was so loud that the person who was there inches or feet away could not discern the words. He said it's the loudest shouting that he has ever heard. So I would suggest, in combination, which has been held time and time again, in combination, the loud yelling, someone who's considerably larger, considerably younger, walking aggressively, walking hastily into the frame of the camera, reaching to the right side.
Now, right there, we need to go back to Justice Gaziano's question, because right there, now reaching to the right side, we're talking about the apprehension of the defendant, right?
Correct.
We're talking about his concern.
Correct.
And whether in the light most favorable to the defendant, this concern is going to mitigate the requirements of intent for murder.
Correct.
There's no evidence in this record that the defendant knows that the victim has a box cutter. How does that get into your calibration?
Well, Your Honor, there is evidence that the defendant said he felt threatened.
Well, I understand, but my issue that I'm trying to get you to address is if we're going to include the box cutter in the analysis, since we're talking about the content of the consciousness of the defendant, how does the box cutter help the defendant at all?
Well, it helps the defendant, and I need to clarify this. The argument is not, as the Commonwealth suggests, that the defendant's state of mind is based on past behavior. What we're saying is the defendant's subjective state of mind at the time, reflected by his expert testimony, was that he was suffering from this heightened state of vigilance.
Okay.
From this deceased. Then, having the deceased, we have testimony from the defendant that they carry as a matter of course, because he does say that we are in a warehouse, we cut things, we might carry knives. He has this deceased who he suffers from hypervigilance from coming at him or walking hastily towards him. And then we have the gesture. Now, I suggest to the court, where we have the gesture to the right side, arguably that would be sufficient for this defendant at a state of mind that he is in, that he says he felt threatened. As far as he's concerned, he could have gone for a gun, but it happened that he had a box cutter.
Now, doesn't
Now,
the
whether,
go ahead, I'm sorry. Please finish.
whether or not again, arguably, we're not in the defendant's head, but according to his expert witness, he was in a vigilant state of mind. So he felt threatened. So the combination of the two would suggest that he could have thought that the deceased was going for a gun because he reached to his right side, but then he happened to have a box cutter. So the combination shows us that the deceased was going for something.
All right, let's put aside what I think is that there has to be some evidence in light most favorable to the defendant that he knows that there's a weapon there. But put that aside for a moment. Am I correct that when he reaches, the victim reaches to his side, that the defendant doesn't shoot him then, but rather the victim walks away and that's when the defendant shoots him?
I don't believe so, Your Honor. Reading the transcript from the testimony is the person who was a witness was behind the deceased. The deceased is considerably larger, so he didn't have a view until the deceased moved out of the way, and that's when he was running. At that point, he saw the gun already out, so the defendant already had the gun out. So from that, one can infer that at the moment where he reached for his right side, the defendant who had the gun in his jacket pocket already had it out. So by the time he starts running, the gun is already out, which is what the witness sees when the deceased clears the way. So based on that, I would suggest there's reasonable inference that as soon as the deceased reached for his right side, now you have, in the context of, in light most favorable to the defendant says, stop. The deceased stops, then starts again coming towards him. And then that's when he reaches and the gun comes out. And then when he clears the view, the witness sees the gun is already out of the pocket. So I would suggest to the court, based on that, as soon as the gesture was made and the defendant felt threatened, he pulled the gun, shoots, misses. And at that point, he's essentially in a daze, as he says, has this outer body experience, and he just chases the deceased down. Now,
What do we make of the fact that that's not how the defendant described it? I mean, the defendant didn't say, I feared he was going for a gun or going for a box cutter. He spoke of a hatchet. The description you give may be supported to some extent by the video, but it's not what he told the police afterwards.
well, Your Honor, he did tell the police that he felt threatened and he didn't know what he was going for. He did tell the police that I was focused on his face and I can't remember. He did tell the police that the whole thing is a haze, that that he can't remember a lot of things. So having him say that, plus the fact that he did feel threatened, I would suggest to the court, the combination, again, would suggest that he had a reasonable fear at the time that he reached for his gun and reasonably provoked and contemplation of this threat of sudden attack, sudden assault, if you will, made him reach for his gun and retrieve the gun and shoot.
But of course, he did get a reasonable provocation instruction.
He did get a reasonable provocation, but then, as part of reasonable provocation, the judge inserted this mere gesture phrase, if you will. So essentially, the judge said, okay, reasonable provocation, but really, the gesture is not enough for reasonable provocation. So he did and he didn't. And then add to that, the Commonwealth coming in at the closing argument and arguing the exact same thing, saying, and then now specifying the gesture. So even if there's a gesture, the Commonwealth says, even if you call reaching to your right side a gesture, that's not enough.
Did the defense attorney argue that he was going for the box cutter and that's why he shot him?
I believe the defense attorney argued that, yes, there was a dangerous weapon involved and that he was in a heightened state of vigilance, and that's why he shot. In some contexts, the defense attorney was also veering towards self-defense, but then there was a discussion at sidebar where the defense counsel was like, well, the first shot was because of self-defense, but then backed off from that a bit. So yes, there was essentially this umbrella of reasonable provocation that he felt threatened by the combination of factors, and that's why he went for his gun.
Okay, is my memory correct that there was a fair amount of running involved in this, and that the victim ran into another area and the defendant followed him? Or am I mixing this case up with something else?
No, there was running involved. I take issue with the fair amount of running because Volume 8, between pages 128 and 130, the trial judge essentially engaged in an argument with the Commonwealth over reasonable provocation instruction. The judge says there wasn't enough time for cooling off period. This happened very quickly. And the Commonwealth says, well, it's more like more than a few seconds, but closer to a minute. So I would say the whole incident, running included, if we go by the Commonwealth's definition of it, was less than a minute. If we go by what the trial judge reflects, it's very quick, not enough for a cooling off period. So I suggest the reasonable provocation would be applicable because there would not be a cooling off period. This was almost instantaneously, seconds, maybe close to a minute. And this is a warehouse to the back of the building.
Can you remind me again what the relationship was between the two men?
They were co-workers.
But
One was a
were
janitor.
they having trouble with each other, or
Yes,
did they
there
have
is-
historical problems?
Yes. According to the defendant, who was an employee for 11 years, the deceased was hired for the past 2 years of that. No incidents during those 11 years. The past two years, the defendant suggests that he was being constantly menaced, bullied by this deceased. He was constantly being called names such as faggot and derogatory names. He would, say things under his breath. There was also a prior incident of a forklift where there were two other witnesses that testified to this, that the defendant took the forklift to use it to reach a light bulb. The deceased followed him on foot, and they did see an exchange of words between the two, but then both witnesses had left when the defendant says that the deceased grabbed him by the neck.
That forklift instance about 6 months before the killing.
That is correct, yes. Yes, there was a period of time before the killing, yes. That was the basis, and the ongoing bullying was the basis of the expert witnesses' diagnosis.
Well, that went before the jury, correct?
That is correct,
All
yes,
right.
Your
And
Honor.
so to what extent does the past relationship of the victim and the defendant factor into this incident of sudden combat? What kind of time frame do we need, and what's reasonable in these kinds of circumstances?
Well, I suggest to the court that the prior hostilities based on case law are not to be considered, as the Commonwealth states in their brief. But that is not what we're arguing here. What we're arguing here is because of this diagnosis of post-traumatic stress syndrome based on prior incidents, at the moment of this altercation is when the defendant suffered from the hypervigilance state of mind. So subjectively, at the moment of this incident, given his diagnosis, the defendant reacted the way he reacted. And for the Commonwealth to take that away from the jury by suggesting to them that objectively there is not enough, even with this gesture, telling the jury that essentially there is no subjective part of this. Now, even though the judge did instruct correctly as to both subjective and objectively, but having said that, the judge then inserted the threatening gesture phrase, if you will. So then it took away the whole reasonable provocation instructions in one big swoop. I see that I'm running out of time, and I just want to briefly address the dismissing of the juror that was impaneled. I want to point out to the court that what's important here is this particular juror, during the voir dire, disclosed her prior assault. It was a subject of questioning Actually, defense counsel pressed the trial judge to question her on this psychological issue. There was some pushback from the trial judge not wanting to go further because he said, I inquired enough, she's impartial. Defense counsel pushes further, trial judge inquires.
What's the judge to do? The judge takes a chance, essentially, finds the person indifferent, and then the person writes a note that's 4 pages long.
And still saying, I'm indifferent. The same person, same circumstance, same life experience, said it during voir dire that I'm impartial. The judge believed her then. Says the same thing 3 times in those 4 pages. I'm still impartial.
Which is a matter of discretion for the judge, correct?
Well, yes and no. I suggested
You
the
don't
court.
think the judge has discretion to find out whether or not someone can continue to serve?
He does have a discretion, but he needs to grant a hearing. There needs to be more than merely saying, but this is an impaneled jury. The whole evidence was closed. All was left to do was deliberate. This is different than just the jury before opening statement or a jury that was impaneled, but we're not now at the close of the evidence.
And remind me when this happened? I'm losing.
This happened at the close of all evidence. The only remaining was instructions and
So they hadn't deliberated.
they had not deliberated, no. But I suggest the only reason she got dismissed was because she expressed giving credibility to the expert witness. And she could have done that. The jurors could have done
In
that.
the legal box that you're in, it's either a deliberating jury or a non-deliberating, and you're in the non-deliberating jury. I know you're making a face, but
No, I agree. It is not, yes, it is not deliberating jury. But if I were to say, if I'm closer to deliberating than not deliberating, I would say we're very close to
I
the
don't think
We're
we
on the
have. I don't
spectrum
think
of
we have a
deliberation.
Yes, Your
I don't think we have a deliberating-ish standard.
I see that I'm running out of time, and I would rest on my brief. Thank you.
Thank you. Mr. Charles, good morning.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. I'll revisit these 2 points in my larger argument, but I did just want to briefly point out 2 relevant, what I view as misrepresentations my sister made with regards to the transcript. If you look at page 38 of Volume 7, the testimony of Sean Dolan, who is a Boston police officer, he explicitly testified that recovered from the pants pocket of the victim was a folding style box cutter knife. So the knife was A, in the victim's pocket, and B, folded up. So I think that disputes any suggestion by my sister.
It was not in a work sheath.
It was not
by
on his
side.
belt, it was not opened up, it was folded in his pocket, found by an individual after he was deceased. The second point, I would just...
Wait. What do you mean by an individual after he was deceased?
His pants were removed during the course of medical treatment. They were later transferred.
Oh, you mean what was discovered after he was deceased?
Yes.
Okay.
I apologize for
That's
me.
okay. I may have
The
missed it.
second clarification I would just like to make, during the testimony of Michael Nigerian, who was the eyewitness to the altercation preceding the shooting, at Volume 3, page 10, going into 11, he testified, and I'm paraphrasing somewhat, but essentially his testimony was, the victim reached toward his right side, almost towards his belt. Simultaneously, he turned around and began moving to the rear of the chemical building very fast. Then he clearly says, at that point, I saw the defendant. He had his arm raised, and he then fired the first shot. So the defendant clearly fired the first shot after the victim had turned around and began running at a fast pace towards the rear of the chemical building. And I would submit that Exhibit 6, which is the surveillance video, which I would invite this court to solicit and review, very clearly shows that the victim is running away before any shot is fired.
So that's my memory of it, but I think what the defendant is saying is that if you look at the video, that there's a possible inference otherwise. And I'm just asking you if you agree in the light most favorable to the defendant that you could come up with a possible inference the other way.
So on the law, I will say no on the law as it exists, but I would just, one last point on the video before I turn to the laws. Again, if you view the video, this all happens in basically less than 10 seconds. The defendant is walking, he is almost out of the door to the warehouse. He turns around, begins to walk back. The victim comes from the other end of the screen. They get maybe within 4 feet of each other, not extremely close. And there is perhaps an inference that maybe his hand is moving downwards, but I would argue that it's far from clear or definitive. And then he immediately turns around and runs away at a fast rate of speed. I mean, this is a split-second interaction. There's clear testimony that the defendant didn't see anything in the victim's hand. He says in his interview, at page 52 of his interview, I can't remember seeing anything. Then at page 54 of his interview, the officers say, there were some words. The defendant, yeah, and that's when all hell broke loose because I just got sick and tired of it. So he essentially admits that there was a verbal altercation. He didn't see a weapon. He pulled a gun out and he shot the victim. I don't think there's any ambiguity there. I don't think there's any basis. But, I mean, it will not surprise you to learn that I also disagree with my sister on the state of the law. I don't mean to be flippant, but the defendant's argument seems to be, well, the law of heat of passion as it currently stands, I don't like it because it doesn't work in my favor. I've cited in my brief, I think Your Honor mentioned a couple of them. I don't feel the need to reiterate them specifically. Numerous cases that have said, essentially, mere words or threatening gestures are insufficient. The defendant hasn't pointed to any contrary case. I don't think whether or not self-defense was also an issue in those cases changes the law. The law is clear that mere words or threatening gestures are not enough. And here, all you have is a two-sided, brief exchange of words, granted in a loud voice between two parties, potentially what can be viewed as the victim reaching down towards his waist area where the clear testimony is a knife was in his pocket, not exposed, not in his hand, not open. And the defendant pulls a firearm, fires at him, and misses him during the first shot, mind you, and then stalks him through the warehouse out into the enclosed chemical yard where he corners him between the fence and a dumpster and fires. I mean, he only hits him twice, but the testimony was he fired 6 or 7 shots to an individual cornered, unarmed, or at least not actively armed, in the back of the warehouse. So this is not a case of heat of passion. I don't really think anything more needs to be said about sudden combat other than if you just watch the video, there's no blows exchange. And since Webster v. Commonwealth, it's been pretty clear that that's required.
If we can go back to the mere words or threatening gestures.
Yes, sir.
Statement is, I mean, I gather there was no objection to that, correct?
To the mere words or threatening gestures?
No objection to the jury instruction.
I do believe there was a sidebar discussion in which defense counsel voiced some concern about the language.
About that language.
I do recall that during the charge conference, I believe, which is in volume 8. I don't have a specific page for you, but I do recall, if I'm being candid, that there was some discussion of the specific words.
Before the closing, I'm sorry, before the jury instructions at the charge conference or after the charge?
I apologize, I don't have a specific recollection, but I guess my larger point would be that even if a defendant raises a concern that based on the facts of his case, the insertion of that language or threatening gestures essentially takes his defense away, that is not a reason not to accurately instruct the jury on the law as it exists. The judge was very clear.
But the question is whether that's, I mean, there may be cases which have said it's okay, but we don't say mere threatening words. We say mere words, no matter how insulting or abusive, focusing on the insulting or abusive nature of the words, and indeed threaten. But the problem with threatening gestures is a threatening gesture can be an assault.
I guess, I'm sorry.
I mean, that, well, I'm not, it's, I should say, question mark. So, I mean, can't a threatening gesture be an assault?
I guess I've two points in response. One, just in terms of the language we use, I take it you were referring to the model instruction. And
Well, the model instruction and the words he used. I mean, he didn't say mere threatening words. He just said mere words. If he had said mere words or gestures, then I would say no problem. It's the threatening gestures where a threatening gesture arguably can be there are things which arguably we would say rise to the level of either being an assault or approaching an assault?
I guess, still 2 points. First, I think objectively, there is no view of the evidence in which any person could say that the act of moving your hand towards the area of your belt where there is not a visible weapon could be construed as a threatening gesture sufficient to warrant a heat of passion manslaughter instruction. The testimony was clear that there was not a knife on his belt. There was a folded up knife in his pocket. And the fact that he may have moved his hand in the direction of his belt is not some inherently threatening. I don't even think viewed in the light most favorable to the
Isn't that, though, a question
defendant.
for the jury? Isn't that really a jury question, whether it's threatening or
No,
not?
because the law says that you don't get the instruction based on mere speculation. There has to be a basis in the evidence for the instruction.
So it's a different case. A victim raises a baseball bat, right? Which would be a threatening gesture. Do you think that instruction is appropriate in that instance?
I think there would be a stronger, the Commonwealth very well might still feel that that's not an appropriate case for an instruction, but I think a defendant would have a stronger, I think a defendant would have a much
So
stronger.
if a victim raised a baseball bat to someone and the other person, you would say there was no reasonable
I
provocation?
think there's a much stronger argument for it there. If I could just, the second point I wanted to make is, notwithstanding my sister's argument in her reply brief that Cologne doesn't apply, I think that case is the perfect example of why.
Because your position is that the defendant got what he didn't deserve. He didn't need, he couldn't have had a
Yes,
provocation instruction.
And so I would point you to the Cologne case. Now, my sister suggests that that case focused on an earlier attempt by the victim to run the defendant over with his car, and that is partially true. And if you'll just bear with me, I just want to read the relevant language from that case. The defendant did not offer any evidence that the victim struck the defendant or his brothers immediately prior to the shooting. The only evidence of immediate provocation that was presented were oral statements that the defendant testified the victim made to the defendant's brothers that he was going to whip all their asses, and his statement to the defendant, I'm going to omit the swear, I'm going to blow your ass away. The defendant acknowledged that the victim's hands were in front of him when he made this statement and that he was not holding a weapon, although the defendant testified that he believed that the victim was going for a gun. This court said that that evidence was not sufficient for a heat of passion instruction. I think he was going for a weapon is not he had a weapon. So this court in Cologne explicitly said that offensive oral statements combined with the defendant's belief that the individual was going for something, when contradicted by the objective evidence that he didn't actually have anything in his hands, doesn't get you there.
Right, but
So I think it's over at that point.
Well, I mean, I get that, and I think I wrote a case, I forget the name, involving somebody leaving the Cambridge courthouse, seeking a restraining order, and then the person said, oh, I thought that they were going for a gun, and we said, no, that's the mere fact that you may have thought that because the hands were by your side is not. But that's a bit different from the Justice Gaziano example, where it's not simply I thought somebody was going to be reaching for a baseball bat, but the person did. I mean, I distinguish between the middle finger as a gesture versus a gesture which may rise to the level of an assault. That's the concern I have with this instruction, which doesn't really separate out the middle finger from the raised baseball bat.
I guess I would say that to the extent that Your Honor has any concerns about the specific language used by the judge, the defendant never should have received that instruction in the first place. He wasn't entitled to any voluntary manslaughter instruction. So to the extent that this court does think that the specific language the judge used was problematic, it doesn't matter. It didn't harm the defendant because under Cologne, under Dyer, under Niemiec, he was not entitled to that instruction. And so he received a benefit to which he was not entitled, and any error in that instruction could not have harmed him.
And let's develop that, because we would have to then look at that, of course, in the light most favorable to the defendant in terms of what the evidence is.
Yes.
Is the evidence in the light most favorable to the defendant what he said, or basically what the video shows?
Well, again, the video does not show the victim brandishing any weapon. The victim
Right,
shows
no,
a
I know that.
fleeting
All
altercation.
I'm saying is, did the defendant say anything which is better for him than what the video arguably would show.
No. I think the defendant said things that are significantly worse for him than what he might want this court to interpret the video as showing. The defendant explicitly said at page 52 of his interview, and the preceding pages, I was lying about him having a hammer. He didn't have a hammer. That was a separate altercation. Quote, I can't remember seeing anything in his hands. He then made, I've referenced some of them earlier, but he made several other statements that were suggestive of him just getting sick and tired of the victim with no actual threat of violence. Quote, I was just coming back, then I guess we made eye contact, and I just got sick and tired of bothering, page 49. Some words, quote, question mark, yes. And that's when all hell broke loose because I just got sick and tired of it, 54. So he's affirmatively stating in his interview, this guy harasses me, I don't like him, I got sick and tired of him harassing me, I pulled a gun out.
So the best that the defendant could do in terms of the version of the facts, it sounds like, would be Nigerian's observations.
That's absolutely correct.
Which were, I guess, obstructed by the victim's, I guess he couldn't see through because the victim was in the way of what.
Until Mr. Ricketts turned around and began fleeing. That is correct, Your Honor.
And you've got a different time period in Cologne. I mean, here.
In which? I'm sorry.
In the Cologne case that you mentioned. So here, I understand your point that your view, even in the light most favorable to the defendant, whatever the movement is to the side, there's a period of time, very quickly, but that the victim turns and the defendant follows at some significant pace, let's say. But in Cologne, isn't it true that you've got the defendant actually going back into the house and getting the gun? So you're not talking about a very narrow amount of time.
So I agree with you factually that that is a distinguishing factor in Cologne. But again, the portion of Cologne that the Commonwealth is focusing on is not the earlier attempt to run the defendant over with the car and his response to go get the gun. After he gets that gun, he crosses the street into a park. And it's at that point that the language I quoted to you is relevant. When he gets in the park with the gun, there's a verbal altercation between him and the victim's brother, in which they exchange words, and the defendant believes he sees the victim reaching for a gun in the park after he gets his gun. And this court said that verbal altercation, combined with the defendant's belief that the victim was reaching for a gun, was not sufficient provocation to warrant a heat of passion instruction. So the earlier car altercation and the intervening act of going to get the gun is not even relevant to that paragraph I quoted you, which essentially just says there needs to be provocation that immediately preceded the act, and here there wasn't, because all there was a verbal altercation combined with the defendant's subjective belief that the victim was reaching for something.
And I assume you agree that if the defendant didn't know the victim had a box cutter, that's just not a relevant factor.
If the defendant, the fact that he did have one wouldn't be a relevant factor? Yeah, I would agree with that. Briefly, if I may just touch on the other two issues. With regard to the juror discharge, it seems to me that this issue is resolved by reference to the statute, 234A, Section 39, which creates clearly two distinct bases on which to dismiss a juror. The first one that's set forth in the statute is, the court shall have the discretionary authority to dismiss a juror at any time in the best interests of justice, period. Then it separately says the court shall have authority to excuse and just discharge an impaneled juror prior to jury deliberations after a hearing upon a finding of extreme hardship. So there is, on the one hand, a requirement to hold a hearing before you excuse a juror for extreme hardship because, as we say at the outset during voir dire, a hardship is not sufficient. We need to probe you and make sure that you actually, I have non-refundable tickets for a around-the-world vacation and I'm going to miss it. So we often have that situation where a trial runs long, maybe a juror needs to be excused, and then you need to have a hearing and probe whether there's extreme hardship. A judge has discretionary authority to dismiss a juror in the best interest of justice at any time. There's no requirement he hold a hearing. There's no specific procedure required at all. And I would submit that here, where the judge is presented with a juror who has essentially just self-diagnosed herself with the very condition the defendant is contending he has, and where he acknowledges that had a challenge for cause been set forth during the original voir dire of this juror, he would have allowed it, I mean, we don't even have to get into the fact that the Commonwealth would have clearly peremptoried this juror if it knew it. I think an easy analogy would be if a former military service member was a prospective juror in this case and had sat down for individual voir dire with the Commonwealth and the defendant and had said, well, you know, I suffer from, and the Commonwealth had inquired and he had said, yes, I do suffer from post-traumatic stress disorder. He's gone. There's no way he sits on that jury. So I think here, it's not a tough call to say that the judge didn't abuse his discretion in concluding that he would have permitted a cause challenge had this come out earlier. The defendant remained with 15 jurors who he had himself agreed at the end of jury selection were impartial and could decide the case fairly. And he got 12 of those jurors to actually and ultimately deliberate on his guilt. So not only was there any improper procedure in excusing the juror, but he also didn't suffer any prejudice from, because she wasn't a deliberating juror who was in his corner, if you want to assume that she would have been inclined to believe him. This was prior to deliberations. And then I guess the last thing I would say just regards to the, I know my sister didn't tell.
Before you leave that, tell me precisely how it played out. The juror gave a note to the court officer, who gave it to the judge.
That's correct.
The judge then brought counsel together to discuss it?
Yes, that's correct. The judge called counsel to sidebar at the close of the evidence on that day. This is starting around, I believe it's page 144 of volume 8. He read the note and then solicited the opinions of both parties as to what they thought was appropriate. The defendant stated, you know, obviously I think she said she can be impartial, I don't think it's a problem. The Commonwealth said, well, we have a serious problem because it sounds like she just diagnosed herself with the very condition that the defendant is claiming he had. And the Commonwealth would have challenged her for cause, and the judge essentially said, it's I think through page 149 is their discussion. You know, he says, my guess is that if this issue had come up in the course of our impanelment process, I would have dismissed the juror for cause. I would not necessarily have awaited a peremptory challenge.
And is there any case law under section 234, I'm sorry, chapter 234, section 9, which says the hearing must be evidentiary?
Section 39.
Section
No,
39.
no. And again, I would submit that this was not a juror removed for extreme hardship. This was a juror removed in the best interest of justice. And the only reference to a hearing in the context of 234, section 39, is when you dismiss an impaneled juror prior to deliberation for extreme hardship, or where you want to dismiss a deliberating juror. And again, I would say in neither case does it suggest that there needs to be an exhaustive evidentiary hearing. I imagine what they envision is perhaps at least hearing from the juror at sidebar, something to that effect. But here we had the juror's words, in essence, in a very detailed, multi-page note. The parties discussed it, and the judge made a determination, and then at the beginning of the next day, he provided an instruction to the jury that they were not to speculate about the reason why this juror was not here anymore. So I think this followed the proper procedure. It certainly wasn't an abuse of the judge's considerable discretion in light of the fact that 15 impartial jurors remained.
All right, thank you.
Thank you very much.